Okay, in the last class, we have started with the unlawful object, and wherein we have discussed about the where the objects can be unlawful. Then, in that case, we have discussed covered the topic that where the objects under section 23 are considered unlawful, there where it is forbidden by law, under what circumstances it is considered as forbidden by law, or the particular act is of that nature that if it is permitted, it would defeat the provisions of law. Then we have discussed about that any activity which involves injury to the person or property of another, there the particular object is considered as unlawful. Then we have covered the aspects that where the court regards the activities as immoral, and then we left at the topic doctrine of public policy. So today we are going to cover under section 23 what do we understand by doctrine of public policy. My dear friends, when we talk about the public policy or when we talk about that certain thing should not affect the sentiments of the society, or where the particular situation is considered that whether the consideration or object is opposed to public policy. So in this particular situation, section 23 helps us that what do we consider that the public policy is there. सो पब्लिक पॉलिसी का जो प्रिंसिपल है उसके अंदर कोई भी ऐसी चीज which involve the intention or which involve the tendency to hurt the we can say the sentiments of the public, so in that case that particular situation can be considered as against public policy. तो जहां पर there is intention है, tendency है, where there can be the injury to the public in any form, or there is the the certain things are for the public benefit or public good, but these are harmful to the public good, so in that case the all these activities would be considered as these are against the public policy. So we have the sometimes we can say that there is a case situation where the Supreme Court says that Inland Water Transport Corporation, that there is the new heads of the public policy can be evolved as a light of fundamental right and the directive principles in the case of Constitution of India. So depending upon the circumstances, depending upon the situations, or depending upon the over the period changes in the society's requirement, so on that basis the doctrine of public policy can be expanded or can be included. So wherever any activity where there is an intention, there is a tendency that it will have the injury or it will affect the public good, all these agreements are considered as against the public policy. And section 23 says कि अगर कोई भी एक्टिविटी है जो अगेंस्ट पब्लिक पॉलिसी है, तो उस केस के अंदर जो आपकी कंसिडरेशन या आपका जो ऑब्जेक्ट है वो आपका अनलॉफुल माना जाएगा. तो अनलॉफुल माना जाएगा तो उसका जो इम्पैक्ट है that the particular agreement is going to be void, there is no enforceability in the particular situation. तो कोई भी promise है wherever this particular object is involved, this is not going to be acceptable. So if we talk about the different examples or different situations where we say that the agreement is against the public policy, so if there is any kind of agreement with enemy where the, our country is at war, so in that case there are likely chances that if we are entering into any of the transactions with them, so they may involve any kind of harmful activity or any kind of subject matter which can be directly or indirectly harm the other person. So in that case, if there is a country with which our country is at war, so if we are trading with that, that is not permissible, that is not enforceable by law. Similarly, अगर आपका कोई भी agreement है जिसके अंदर आप interfere कर रहे हो in the course of justice, there is interfering in the course of justice. So in that case also, this is not good, because the justice, or we say that the social system and the law is being enforced for the public good, for the protection of the society, for the normal working of the economy. So if there is the law, any of the agreement which interfere in the course of justice, so it means that we will taking into account that it would defeat the provisions of law. तो अगर हम लॉ के प्रोविजंस बनाते हैं और उसको तोड़ने के और उसको कैंसिल करने के लिए कोई परमिसिबल कर देते हैं, तो इट मीन्स दैट देयर इज नो नीड टू मेक दोस प्रोविजंस. So in this case, if there are any kind of agreement which interfere in the course of justice, that will also be considered as opposed to public policy, because law is being made to protect the interest of the society, to protect the interest of the public. तो उस सिचुएशन के अंदर अगर हम कोई भी ऐसी एक्टिविटी को एनफोर्सेबल बाय लॉ करते हैं जो कोर्स ऑफ जस्टिस के बीच में आपको इंटरफेयर करती है या उसके प्रोविजंस को डिफीट करती है, तो इन दैट केस दैट इज नॉट कंसिडर्ड अगेन इन रिटर्न, वो अनलॉफुल हो जाएगा और वो वॉइड हो जाएगा. Then there can be certain kind of agreements. We can talk about the agreements for stifling criminal prosecution. When we talk about the criminal prosecution, so criminal prosecution means that if someone has indulged in any kind of crime, so in that case such person is required to be punished, right? So if we permit that this particular person has made the crime, but let us exempt this person on certain grounds, so that is not allowed. So you should not make any kind of that, that if there is a particular activity, particular transaction is going to result into a crime, and you have allowed that crime, or you have allowed the other person to do that, and you have certain kind of personal interest or benefit out of that transaction, so such a transaction is considered with the unlawful object. That transaction will be considered as opposed to public policy. For example, that A knows that he is having certain kind of information which is a crime, and such information you are saying that I will not disclose, or I will not share this particular information, and in return you give me 5 lakh rupees, right? So in this situation, you are protecting some crime, you are entering into a contract where you are stifling criminal prosecution, or you are entering into the contract wherein for your own personal benefit you are supporting, or you are hiding, or you are not sharing the information. So this particular contract or this particular situation is unlawful. This is we can say void. So even if after not disclosing the information, you have claimed this amount and the other person has refused, you cannot do so, because this particular agreement is not enforceable by law on the ground of that this particular agreement is considered as opposed to public policy. Then there come maintenance and temporary. In this case, what happens that when we talk about the maintenance, in this particular case, one person is helping the other person financially for the litigation in which third person has no legal interest of his own. So in this case, one person A has supported B to file a case against C. लेकिन इस केस में ए का कोई इंटरेस्ट नहीं है उस केस को फाइल करने के लिए, तो वो बी को फाइनेंशियली सपोर्ट कर रहा है सी के अगेंस्ट केस फाइल करने के लिए, बट उसके थर्ड पर्सन के लीगल इंटरेस्ट में ए का अपना कोई इंटरेस्ट नहीं है. Then in case of champarity, what happens that in this case there is agreement कि for example A has given B some money, that in this case if you will win a case with C, then we will share 50-50%, whatever profit or whatever compensation we'll get. So A is supporting the financially B with a point of view to have the share in the legal suit. So this is called as temporality. So if there is any kind of maintenance or temporality, this particular contract is not enforceable, because for the want of there is a consideration, no consideration, and there is that is that you are for your own benefit, you are asking the other person to file a legal suit. So in this case, in both the cases, financial or professional assistance is provided, but in this case the only whatever money is being received, if you are getting an addition, अगर professional services के लिए आप support कर रहे हो, that's fine. But other than that, if you are targeting on getting the financial or share from that, then in that case it is unlawful, it is not allowed by law, and the particular agreement is declared to be void. Then in continuation, we have a situation where we say that trafficking in public offices. So you people are also aware of that in certain situations, certain jobs or certain activities are being held in the public offices, or to get the work done out of way. So in this particular situation, if there is any kind of trafficking, you are sort of giving a bribe or money, or entering into any of the contract to obtain a seat, or to obtain a job. So this all these things are not considered as valid, or this will not give rise to a valid contract. So in this particular situation, what happens, that we have to talk that there is any kind of activity which is being enforced, or which is being done with respect to the public offices, educational institution, or any other thing, this is considered as against the public policy. So even if you are talking about that you will get admission, and for that you have entered into a contract and you have promised to pay some money, and later on the other person could not get it, and you have filed it to get the money back, so that is not allowed. So this kind of activity is considered opposed to public policy, hence unlawful, and hence not enforceable by law, does not give rise to any kind of legal obligation. Then there can be a situation where you are entering into an agreement. Just give me a second. So there is a situation where there is agreement creating interest opposed to duty. So if you are entering into the agreement where you are, instead of you're compelling or you're guiding the other person not to do his duty, or beyond his duty, he gives you something extra advantage, or you are entering into the agreement. So wherever there is a conflict, or you are entering into the contract where the person is doing not doing his duty. For example, there is a file which is to be given as per a particular time period, and you have given say 5,000 rupees to that person, that this file should be clear today itself. So he is doing his duty. It is his duty to clear the file and all these things. But bribing the person, or creating any agreement wherein the person is doing something opposed to the duty, in that case, this particular agreement is not valid. So that person has taken the 5,000 rupees but have not given you the file on time. You cannot file a case in the court of law, because the object of the particular agreement is unlawful, and once it is unlawful, it is void. It is void means it does not give rise to any kind of legal obligations. It means it is ICA rules are not applicable, and this is not enforceable, right? So impact would be this. So in this case, any activity wherein you are guiding some person, you are asking some person to do any activity which is opposed to his duty, that is to be taken into account. Then there is a question where we say that where you have entered into the agreement where you are restricting some person to use his personal liberty. So, as per the fundamental right, every person has the certain duties or certain rights or the personal liberty. So, in that case, wherever the situation is where you're restricting some person that he is not supposed to do the particular activity, or he is not supposed to enter into the agreement, or if you are there is suppose A has given a loan to B, and while giving a loan, there is a verbal agreement that on the basis of this loan, you will give me 10% share in your business. So in this case, the person is taking undue advantage, but there is no, agreement or no consent related to that. So the person is, if he is making any agreement related to this, so this is you're restricting the person to take a decision, or where the loan is being given on interest, but you are compelling the other person for any other decision. So that is not considered as lawful. That will be covered under the, we can say, the unlawful agreement or opposed to public policy. Then there is, if there are certain kind of parental duties, and you are entering into an agreement where you are restricting the party not to exercise his rights as a parent. So in that particular case, such an agreement is also considered to oppose to public policy. So if there is a person, a minor child is there, and the legal guardian is there, so in that case the right cannot be by an agreement transferred, that the parents do not have the right or the guardian have got the right over the minor. So if there is any kind of agreement which interferes the course of parental duties or the performance of parental duties, so in that case, such an agreement is considered as opposed to public policy. Similarly, there can be a situation where we talk about marriage brokerage agreement. So if there is a person who compels the other person to break the marriage for money and to marry the other person, in that particular situation, such an agreement is not valid. A has given a loan to B. In return, B is supposed to divorce her husband, and then she's going to marry A. So in this particular case, such kind of marriage brokerage agreement, these are considered as opposed to public policy. These are not valid, or even if there is any agreement wherein the any agreement with respect to case of the dowry or to the parents or to the family. So such kind of agreement is not valid. If you have given something and that is you, then also you cannot take it back as an agreement. So if there has been any agreement with respect to any things which are being given for the this particular marriage brokerage things, so in these case these are covered under the Dowry Prohibition Act, and these are not enforceable by law, and this cannot be considered as the valid contract. Then there can be the other situations that if you are taking undue advantage of certain businesses, if you are entering into the person where you are influencing the election in the public offices, or you are making bid against each other to take a particular contract. So all these kind of agreements are considered as opposed to public policy. For example, A and B are friends and they are making bid against each other to get a particular thing, and they are not allowing someone else to bid for that. So this particular agreement is also considered as opposed to public policy, because they are having the intent to take a particular contract, and they are making the bid opposed to each other just to have the particular thing. They are increasing the bid one by one. So you must have seen in certain situations, in certain kind of activities or series in your course. Now, if we talk about section 23, so section 23 is over, wherein in section 23, starting from that which are the agreements which are unlawful. carries unlawful object. So these all these points we have discussed till now. Now we move to section 24, wherein it talks about that where the agreement, अभी तक हम बात कर रहे थे कि जो सब्जेक्ट मैटर है वो आपका अनलॉफुल है, चाहे वो इन केस ऑफ फॉरबिडन बाय लॉ है, चाहे वो अपोज टू पब्लिक पॉलिसी वाले केसेस हैं, या फिर सर्टेन काइंड ऑफ activities wherein it defeats the provision of law, involves injury to the person or property of another. So till now we have a discussing about the कि किस circumstances में जो objects हैं वो आपके unlawful हैं. Section 24 talks about कि अगर आपका जो consideration या आपका object है वो आपका partially lawful है और partially unlawful है, then what will be the legal impact of these kind of cases? So in this case, what we have to see is that if there is consideration or object is unlawful in part, so if it is separable, then in that case the separable part is going to be valid, and if it is non-separable, then in that case whole of the agreement, 100% of the agreement is going to be declared void, is not going to be enforceable by law. For example, A has given a loan to B, and B has utilized that money to give it to C to kidnap D's son, right? In this case, A does not know the purpose of the loan. He has given a loan as a normal routine. So in this case, if it is separable, this is going to be performed, this is going to be valid. But if A knows the purpose of the loan, he has given the loan to B and he knows that B is going to utilize it for this particular activity, then it is unlawful, because we say that the associated work or the subsequent transactions are also tainted with illegality. So, section 56 in continuation, we say that if it is separable, it's a normal course of transaction wherein the party is not aware of the purpose of the contract, and these are separable contracts. The separate one, the valid one will be performed, and the invalid one will be void. So, but in this case, section 57 says that if there are certain promises where there are partly there are the things to do certain illegal activities and certain illegal activities. So in this particular case, अगर legal act separable हो जाएगा illegal से तो वो perform होगा, otherwise this is subsequent transaction is also tainted with illegality. So that is going to be not enforceable by law. So in this particular case, we have to understand that whether a particular transaction is legal or illegal. So जहां पर आपके consideration और object unlawful in part होते हैं, और जहां पे कुछ acts legal है और कुछ acts illegal हैं, और legal acts separable नहीं है illegal से, तो पूरे का पूरा agreement illegal and void हो जाएगा. And section 57 says कि अगर वो separable है तो separable वाला जो legal part है वो आपका वैलिड हो जाएगा, और जो इलीगल पोर्शन है which is separable and which cannot be performed, that is going to be void, that is the whole of the agreement is going to be void, it is not going to be performed. And section 58 says that is the alternative promises. One is legal and the other one is illegal. So in this particular case, if alternative promises are legal or illegal, so legal branch alone can be enforced and illegal branch cannot be enforced. For example, A and B has agreed that A will pay 1000 rupees, which B shall afterwards deliver to A, either rice or smuggled opium. So this is a valid contract to deliver rice and void agreement to provide opium. So in this particular case, अगर reciprocal alternative promises में you have two option A and B, और A आपकी लीगल है और B इलीगल है, सो उस केस के अंदर अगर आप ए परफॉर्म करते हो तो वो वैलिड हो जाएगा, और बी परफॉर्म करते हो तो वो इलीगल होगा, अनलॉफुल होगा, एनफोर्सेबल बाय लॉ नहीं होगा. और सेक्शन 57 में it talks about the reciprocal promises. That reciprocal promises means that we have to do something in return. तो उस केस में अगर लीगल परफॉर्म होता है तो लीगल हो जाएगा, इलीगल परफॉर्म होता है तो वो अनलॉफुल हो जाएगा. एंड सिमिलरली इन फर्स्ट केस जहां पर आपका पार्ट में आपका ऑब्जेक्ट लीगल और इलीगल है, तो इफ इट इज फॉर लीगल वन it will be performed. If it is illegal one, it will not be performed. So with this particular topic is over, and we have discussed up till now कि section 23 कहता है कि every agreement which have the unlawful object or consideration is void ab initio, and no legal obligation, no legal performance, no legal relationship. So in that particular case, the total whole of the agreement is going to be void. And if there are collateral transactions which are tainted with illegality, so collateral transaction जब अगर पार्टी अवेयर होती है इलीगल पर्पस के लिए मेन ट्रांजैक्शन का, तो उस केस में कोलेट्रल ट्रांजैक्शन भी आपकी जो है वो इनवैलिड हो जाती है, अनलॉफुल हो जाती है. फॉर एग्जांपल वी हैव डिस्कस कि ए ने बी को लोन लिया और बी ने उस लोन को आगे सी को देना है किडनैप करने के लिए. तो व्हेन यू नो द पर्पस ऑफ द लोन, then in that particular case the collateral transaction are also going to be tainted with illegality, hence going to be enforceable by going to be unenforceable by law, will not give rise to any of the legal obligation. And similarly, doctrine of restitution we say is not applicable in case of illegal agreement, but where the parties are equally guilted, then the defendant is in a better position as compared to the plaintiff. So now we can take up the questions from this particular topic, and if you have any queries we can discuss, and if you want me to repeat any of the point till now, we can discuss those points as well. Yes, right? You can